Good morning, gentlemen.
Good morning.
You each will have 15 minutes, and the appellant may reserve. Thank you.
May it please the court, Joseph Stafford on behalf of Darren Wells, and I'd like to reserve 5 minutes for rebuttal. This is actually, I believe, the fourth time this domestic relations case has been before the court. There are two recorded decisions from 2012 to 2014. One case was dismissed for a non-appealable order. So the 12 and 14 case, I believe Judge Moore, Judge Carrie, you're on those cases. I believe individually you each wrote one of the decisions. So I will not bore you with the facts of the underlying litigation. However, when we get to this point, and what this appeal has to do with is the remand from the December 14th decision. So there is a remand. This case is the second time in which there has been an order issued as prepared by counsel for Ms. Wells. The 14 decision, the court adopted a order that was prepared and submitted and adopted with no changes to the entry itself. Led to appeal. Mr. Wells lost the appeal except for the issue of the arrearage for determination. This court found that there was no evidence to support the court's determination. So it goes back on remand. 1 year ago today, on June 16th, in the morning, something most bizarre occurs, which I have not been able to explain to my client as of this date. So there's an entry issued at 8:05 a.m. in the morning granting the motion that had yet to been filed. The motion then is filed at 9:06 a.m. So there's a granting of a motion even before it's filed, and again it's submitted by counsel determining arrearages of almost $300,000. The numbers do not make sense. They resubmitted the same exact evidence that this court found was inconsistent with the testimony in the prior entry. You can't resubmit. The Nolan case, the Supreme Court case from 1984, Nolan v. Nolan, the law of the case, if this court found that there wasn't proper evidence to begin with, you can't just resubmit it to the court on an ex parte basis and have the court grant it without the opportunity to be heard. If you look at the proof of service says June 16th, they're sending it out by regular mail. We responded, but we were late in our response because we did not know the court was going to grant the motion on an ex parte basis. The local rules of court for Summit County Domestic Relations Court, specifically Local Rule 2.08, prescribes the procedures in which you are to file a motion, get a hearing. Let's assume the court said, I saw the motion, I believe the motion is valid. The local rules you jump to next is Local Rule 28.01, .02.03 that describes how it's to happen. The court says, fine, I'm going to grant the motion. Counsel, prepare the motion. You have 14 days to do it pursuant to the local rule. Opposing counsel would be myself. I have 7 days to respond to that, object to it, make my record, whatnot. But in this particular case, that did not happen at all. You can't grant this sort of motion on an ex parte basis, and clearly you can't grant the motion before the motion is filed. There is no jurisdiction to grant a motion that has not been filed. There is no explanation on this other than the fact that the motions were granted on an ex parte basis with depriving everyone the opportunity to properly respond. I can understand, and perhaps the court can view it as this is just an arrearage, but we're not talking about a little bit of money. We're talking about $293,000 if you believe what is indicated by Ms. Wells or Ms. Park in reference to this. Unfortunately, under this case, the reason why this litigation never ends is because we're having orders issued like we're having issued in this case. If this court wants the litigation to end, it should reject the notion that you're going to find someone in contempt on arrearages and basically say you order these funds and we're going to give you the option of how you pay it, but then we're also going to have CISA collected on top of it. There's been a great deal of money paid by my client through the years, and give you the breadth of his payments to know that he doesn't come before this court complaining about somehow he's overpaid. He's complaining about the procedures and the lack of due process. The original temporary support, or the original order in this case, for spousal support, he paid over $1.4 million. The court then went and originally gave him a child support order of $1,400 a month because he was paying substantial funds in spousal support. The court years later went back and then said, your child support order, not only was it $20,000 for spousal support, but we're going to go retroactive back in time, and we're going to determine that you owe $13,000 a month in child support on top of it.
But that was because the initial order was a temporary order, right? So didn't the court come back later and adjust it based on the numbers that were known later at the trial?
Well, that is a burr in my saddle, that issue, because it does not make sense. It is contradictory to what actually went on. I know I've lost this issue before you. I know that this issue has been determined as res judicata, but that simply isn't the facts. There was a temporary support order where he paid $10,000 a month and picked up and was paying all the expenses of the children, including private school.
And that was brought up at trial.
That was brought up. It was. And the court went back and said February 1st of 2007, even though there was no motion even pending to take it back that far. Yes?
Well, the original complaint would have taken it back that far.
My client filed the complaint. The original complaint would have been to the answer and counterclaim.
Right.
The date, I understand what happened. I explained it to my client sometimes that this isn't a perfect system we have. And, I've explained that to him repeatedly. But this I cannot explain. Any layman, and my client isn't just ordinary layman. He's no longer with Goodyear, but was with Goodyear as the CFO, and then became president of Goodyear of Europe and North Africa. He's since lost that position, but he is no ordinary layman. He is very smart, very articulate, and to try and explain to someone how a motion is granted before it's even filed, with no opportunity to be heard, when this court fact issued an order specifically addressing that there was no evidence to support the urged determination. And the practical matter, you would ask me, why is it important now? Well, because what happened after this order was issued, not only was CISA collecting, but then there was garnishment, attempts for garnishment proceedings against my client, which led to a whole host of litigation. My client is claiming, I'm paying on my arrearages, how now can you collect on a judgment? So what should actually happen in this case is that all the evidence is presented to the court on all the payments he has made, because CISA went about not collecting just $13,000. They were collecting $16,000 to $18,000 a month since the last order of court in 2013. So he's paid all these extra funds. Counsel wants to just have an entry that he can go execute on, and then my client's left trying to sort it out and come back to court to say, I've made my payments, what you're doing is improper. Because subsequently to the last order of court, one of the children became emancipated, and one child set to emancipate, I believe, a year from now. So under the circumstances of this case, to finally put this case to bed, I'm humbly suggesting to the court reverse with a mandate that the court follow your original order, that the court actually take evidence on this. You can't use records that are 2 years old and say this is what someone owes, and maybe perhaps we'll give you credit for whatever you've paid, because there's issues of direct payments, there's issues of direct benefits the children derive from my client that he paid before the order came out in 2013. So if you're going to do an order back to 2007, 2013, you can't say we're merely going to look at what you paid through CISA if in fact there was direct payments made.
Depending on how the direct payments were construed.
I agree, but all we're asking for is the opportunity to make the argument. That's all we're asking for, is that opportunity. We're not saying we're right or wrong on that point. We're merely asking at this juncture for the opportunity to be heard. That if the court determines that even though they made the order retroactive and they're going to deny the direct payments to go towards arrearages, so be it. But we should be allowed to present that to the court. We don't believe summarily the court can grant something before it's filed, say you owe this money, foreclose that opportunity to be heard. Because what the entry does, it says, we're only going to give you credit for payments you made through CISA. That's not fair. You can't go back 6 years and say to someone, even though you've paid everything, even though there's direct payments, we're not going to consider it. So basically, all we're asking for here today is the opportunity to be heard. This case will not end under the circumstances that are there, and the litigation will be horrific. And so, once again, I merely ask for this matter to be reversed and a mandate be issued to the trial court to actually follow the directions of this court pursuant to the Nolan decision, that the court cannot just reissue the same decision without a proper hearing. Thank you.
Thank you.
Good morning, Your Honors. My name is Richard Rabb. I represent the App.No Carrie Park. Needless to say, and we think our brief provides, what Judge Hayes did in this case was appropriate. A mere review of the judgment entry indicates a few things. Number one, this court's last remand simply asked for a calculation. It said specifically, to the extent that the trial court failed to explain this discrepancy, which was a calculation, the second assignment of error is sustained. And then the remand says in paragraph 40, Father's second assignment of error is sustained in part and overruled in part. This matter is remanded to the Domestic Relations Court for clarification and recalculation, if necessary, of the amount of father's child support arrearage for February 1st of 2007 until July 1st of 2012. And that specific instruction is also included in your decision, a misunderstanding of how Judge Hayes had arrived at the number. The judgment entry that we are here on today that was issued on June 16th, 2015, specifically addressed that issue. Any arrearages that fell outside of that period of time were found at the end of the order where the judge simply said, CSEA shall determine the arrearages that have accrued from July 1st, 2012 to the present. As to the appellant's arguments that the order issued was simply prepared by Ms. Park, I think that alleges some impropriety on behalf of the judge.
Well, what are we to make of the timestamp and the fact that the motion was granted before it was filed, and that the numbers don't lie?
Right, I do understand that, Your Honor. I cannot account for that except that it was issued by email. Judge Hayes has a specific requirement for his cases that everything goes by email. So when that was sent to Judge Hayes, it was also sent to opposing counsel. You know, so everybody had it at the same time. How Judge Hayes did what he did, I don't know as far as the timing goes, but that would have been how he would have obtained the motion, just like counsel would have obtained the motion. I would also say, and we also briefed quite extensively, that a hearing here is not necessary, a motion here is not necessary, and a proposed judgment entry is not necessary. There is no requirement at all for a hearing. The court could have simply done this sua sponte. The motion itself was simply filed to say, hey, it's been a while since the Court of Appeals ruled. Can you, here's what we think you ought to do, you know, can you rule? And that was filed. Also, the suggestion that that somehow the numbers in this case, Mr. Stafford referred to $293,000 in arrears, somehow makes this case unique from the next case. I would also say then we should start talking about perhaps Mr. Wells' income of $5 to $10 million, all of which is, you know, out there in the public record. I don't think that's for this Court of Appeals. I think the fact is that all of these issues, including the calculation of the arrearages, were done, including the date that it commenced, the fact that it's a burr in Mr. Stafford's saddle, that it has already been determined and that that issue is already res judicata. I can't help that. This remand was very, very slim. It was sent back for one reason. There was no requirement for a hearing in that regard. I would also say a reference to the local rules is nothing more than a red herring here. Local 2.8 talks about having a motion set for hearing, but again, there was no requirement to have the motion set for a hearing. So that's number one. And Local Rule 28 also has no applications. All that talks about is who's supposed to prepare a judgment entry when a judge issues an order to say, hey, prepare a judgment entry. So that didn't accrue here either. I would say, Your Honors, that because this court had a very, very limited recalculation for a very limited period of time that was defined in your court order, that what Judge Hayes did here was wholly appropriate. The standard of review here is an abuse of discretion. The burden falls squarely on Mr. Wells to overcome that burden, to show that it was outrageous what Judge Hayes did. And I would, if I didn't say already, there is simply no requirement for a hearing, and we briefed that for the court as well. Thank you. Unless the court has any questions for me, I am concluded.
I don't believe so, thank you.
Thank you.
We acknowledge that this is an abuse of discretion standard. On an abuse of discretion standard, you have to determine if the court acted arbitrarily. Mr. Rebb, my learned colleague, would have you believe that somehow this matter was emailed to the judge. The judge filed his document with the clerk of courts, walked down and had his entry filed first, then walked down and had the motion filed. I've practiced a long time. I have yet to see any judge, and this is no offense to judges, file documents on behalf of counsel. The idea that Judge Hayes, a visiting judge, well-respected jurist, walked down to the clerk's office and filed this motion on behalf of Ms. Wells simply defies logic. Someone walked it and filed it to Judge Hayes. It was granted on an ex parte basis. The idea that you have an entry being, or a motion being granted before it's filed, just reeks of an abuse of discretion. We can't change those. There's nothing about this that I can change. It's unfortunate. If Mr. Rabb is right, nothing was done, or no hearing was required, then why was it done in such a fashion? Mr. Wells was deprived of any due process rights he had. Now, Mr. Rabb can say he makes a great deal of money. He did. Does that mean the rich is not entitled to due process? We say because they have a great deal of money, we set aside the local rules of court, we set aside the rules of procedure, we set aside the rules of evidence, and we just do what we want to do when we want to do it to someone because they're rich? Of course not. The problem that we have in this case is that the court originally made the order retroactive a period of time from 2007 to 2012. And then the order that's now issued talks about arrears from 2007 through 2015, 8 years. And then Mr. Rabb had, and this is an entry signed by Mr. Rabb, he signed the entry that the judge signed. He prepared the entry. There's no question who prepared the entry. This wasn't Judge Hayes preparing the entry, this was Mr. Rabb. He filed it, he got the judge to sign it, and it's filed before the motion is done. Let's not look at it any other way than that happened. My issue is a due process issue. So we go from 2007 to 2015, 8 years, and what they did by doing this entry was eliminate any argument Mr. Wells had for direct payments. Now the direct payment issues also has to do with private school tuition to the tune of over $50,000 a year, direct payments on behalf of the children, which he has the right to argue. Now the court could say, I'm not going to give you any credit for it, but Mr. Wells should be able to make that argument and have it properly heard before the court. If the court doesn't like the argument and says you're wrong, I'm not going to give you consideration for it, so be it, but at least he'll be given the opportunity to make the argument. His direct payment argument is in excess of $300,000. So the swing here is substantial. And so once again, in terms of a litigant, how am I to explain, and this will, if you affirm this decision, you'll have to explain how this occurs in your decision. A motion is granted before it's filed, and your prior order means that we don't have to have a hearing, nothing has to happen except an entry has to be submitted by counsel. The problem is, what's the fallacy in the argument is, there was a motion filed and an entry submitted. The entry was granted before the motion was filed, and the local rules then, if you're filing a motion, are applicable. How else do you get around the local rules of court? This, on its face, deserves a reversal just on the mere timing of the issues. And it is substantial funds. So once again, I humbly request a reversal in this case, and that Judge Hayes be mandated to follow the directions of this court from its December 2014 decision. Thank you. Have a great day.
Thank you. Thank you, counsel, the both of you, for your presentation to the court. The court will take the matter under advisement and issue a written opinion will be sent to both of you. And then you can look on our website where we release our opinions lunchtime. Thank you.
Thank you.
Thank you.